custody by virtue of a court order in this Guantanamo litigation, which has now gone on for 6+ years. The D.C. Circuit just issued a decision in one case that might lead to the release of a Uyghur, but for the most part, we've been fighting about just whether they get in to the courthouse door. And I think from the detainees' perspective, it was a do-over because the Supreme Court, as they would look at it, decided this case 4 years ago in Rasul. It decided that the Guantanamo detainees have a right to come into court. Of course, in the interim, that decision was predicated on a statutory interpretation of the habeas statute, and in the interim, Congress changed the habeas statute precisely to respond and to take away habeas review, and therefore the court had to address it this time as a constitutional matter. But still, it's a threshold decision. In other respects, however, I think it's a truly momentous decision. It is the first time that the Supreme Court has ruled against the President and Congress acting together on a matter of national security in a time of crisis. The first time. The Supreme Court has traditionally been extremely deferential to the President acting alone, and even more deferential to the President acting with Congress on matters of national security. As everyone knows in the room, the court upheld convictions of many people for speaking out against the war in World War I. It upheld the Japanese internment in World War II. It upheld the Cold War anti-communism measures until McCarthy had been censored and McCarthyism was on the wane. And the one sort of case where the court stood up to the President was Youngstown Sheet and Tube, a case in which it found that the President was acting contrary to the implied intent of Congress. So here you had Congress and the President acting together, and yet the court struck down their actions. Secondly, it's the first time ever that the court has extended constitutional rights protections to foreign nationals outside of our territory. That's a remarkable fact as well. In fact, in 2001, shortly before 9/11, the court issued a decision in which Justice Breyer said, of course, foreign nationals outside of our, he said aliens, I don't like that term, but foreign nationals outside of our border have no constitutional rights, but once they come into the United States, they have constitutional rights. This decision overturns that line of thinking, and it's only the third time in the court's history, 200+ years, that it has struck down a limit on the court's own jurisdiction. Only in 2 prior cases that are studied in federal courts classes and then quickly forgotten by those who graduate, has the court ever struck down a jurisdiction-limiting statute. And the idea has always been the court gains legitimacy in a democracy by the fact that Congress has the power to control its jurisdiction. And if the court were therefore to sort of override that power, it would lose that legitimating function that Congress, not having stripped it of jurisdiction, would give. So it's, I think, a momentous decision and an unprecedented decision in many respects. So what I want to talk about is what accounts for this. I think a number of things clearly don't account for it. This is not a radical or even liberal court, right? This is the court that voted President Bush into office in the first place. It's the precedent in the case was pretty clearly on the government's side, with the exception of some throwaway sentences and footnotes in Rasul. The Johnson versus Eisentrager case had held in 1950 that enemy aliens, as they put it, who are held abroad, have no right to seek habeas corpus review. It's also not a court that has generally been enamored of habeas corpus, right? Over the last 20 years, the court has dramatically restricted the scope of habeas corpus, in particular in the context of the most familiar context, that is where it is used to review the constitutionality of a prior state or federal conviction. So what accounts for it? And I think there are really two factors. One is the notion, the concept of habeas in this particular setting, I think, is critical. And the second is international developments. Let me talk about those in turn. Habeas is different here than in the routine habeas case, which reviews a criminal conviction, because here you're talking about habeas review of an executive detention, where there has been no judicial determination. In the criminal context, of course, there's already been a trial in which constitutional claims can be raised and the like. And the court has said that habeas is the core of habeas corpus. The habeas corpus that was adopted first in England to respond to the abuses of Charles I or Charles II, I'm never sure which one, I'm sure somebody here knows, but was designed to get at executive detention. And it is a lot of people don't understand it, I think, particularly outside of the legal world because it's in Latin, but it's a pretty basic idea, right? My son, several years ago, my son, who at the time was about 3, I was going up to New York to represent someone in a habeas case, and I called home, and my son had, at 3, didn't have much of a sense about what I do as a lawyer. Like file briefs in court and what is all that about, right? But he got on the phone and he said, "Daddy, did you get him out of jail?" Right? It was that basic. And I remember that at that time, one of his favorite books was Curious George. And the first Curious George book, for those of you who are parents, you may recall, there's a period where Curious George gets thrown in jail for some infraction. And I remember my son, whenever he would turn to that page, he would start to well up and start to cry. He's clearly a born defense lawyer. But I didn't do it. I was, 3 years old, but I'm proud of it. But it's that basic, right? Daniel Patrick Moynihan once said, if I had to choose between living in a country where I had the right to vote but no right to habeas corpus relief, and a country where I had no right to vote but a right to habeas corpus relief, I would choose the latter. Right? And you think, well, how can that be? I mean, everybody votes. How many people really get locked up? Surely the right to vote, democracy is fundamental. And he's saying, no, the right to habeas corpus is more fundamental than the sort of core right in democracy. And I think that's right. Because at the end of the day, if the government can lock people up and deny any ability to go to court to challenge the legality of that detention, what does it matter if you have the right to vote? Mugabe gives people the right to vote. What does it matter if you have a right of free speech, the right to bear, well, it might matter if you have the right to bear arms, but so it is, in a sense, I think, the sine qua non of limited government. Without habeas corpus, you don't have the concept of limited government. And so I think that did play a critical role. Justice Kennedy talks about the suspension clause being the only individual right protected in the body of the Constitution itself. Right? At a time when they didn't even think the Bill of Rights was necessary, they thought one individual right was necessary, and that's the right of habeas corpus. The second, I think, important factor here is international developments. I don't think this decision would have been possible without sort of globalization and the development of international human rights that Vijay alluded to. I mean, without globalization, Al-Qaeda, Monsanto, without chemicals, life itself would not be possible. Without globalization, Al-Qaeda itself would not be possible, right? There's an international terrorist organization that uses the ability to get easy access to international transportation, international finance, the net, and the like. Without globalization, I think the international response to Guantanamo, which was critical, I think, in the court reaching this decision, the condemnation